You're first.
Michael Fisher. I happen to be an Illinois lawyer, but this is a pro se appearance. As you,
What part of Illinois are you from?
I certainly appreciate the opportunity to appear before the panel this morning. As you know from our brief, the position our position is that the lower court erred in granting judgment to the bank because the bank's sole claim to its right to foreclose is based upon the possession of the note that it acquired through this assignment, which at the very least is a defective assignment. We refer to it in our brief at times as a fraudulent assignment, but we also say at the very least it is a defective assignment. When I say the assignment is a fraudulent or it is at the very least a defective assignment, I'm referring to the signature of the notary. Matangwin is her name. I'm referring to Matangwin's signature on the assignment that the bank relies on for its authorization to foreclose. The problem with the bank's position is that the notary's signature on this assignment bears no resemblance whatsoever to the notary's signature on her official oath of office. And we have presented those exhibits in our brief. In fact, the signature that purports to, on the assignment, to be the official signature of the notary, the signature on the assignment of mortgage and the official signature on the notary's official certified oath of office are drastically different. And I think, frankly, it's an insult to the court and to the lower court to suggest in this case, in this particular case, meaning with respect to these two signatures, that anyone would need an expert to tell us that the signature on the assignment of mortgage is not the notary's signature. The signature on the assignment is not Matangwin's signature, and here is the whole point. If the notary's signature on the assignment is false, for whatever reason, then of course the assignment of mortgage is invalid and it conveys nothing to the bank. That being the case, the bank has no standing to foreclose. The case is really that simple.
So what is the remedy you would be seeking? The first mortgage is still of record, though.
Well, I'm not seeking the remedy. It's the bank that is seeking the remedy.
Well, you're seeking a remedy on appeal. You want reversal for further proceedings, to have the proper bank bring the foreclosure, or to redo the assignment?
Well, that would be up to the bank, Your Honor. I am not the mortgagor in this case. I simply bought the property at a foreclosure sale.
Yeah, foreclosure on the second mortgage, and you're saying
correct.
The first mortgage was not properly assigned.
That's correct.
You're not saying the first mortgage was not duly recorded, and it's still out there.
The first mortgage was definitely duly recorded back in December, I believe, of
08.
08.
So how does the reversal help you, is what I'm asking you?
How does the reversal help me?
Right.
Well, at least at that point, it would be up to the bank to choose whatever appropriate method, if there is one, to foreclose.
Okay.
And I have title to the property. I was given title to the property and recorded it prior to anything that the bank did. The bank had no interest in this property prior to 2012. So it would certainly be of great benefit to me. The bank would then have to figure out some other system other than what I consider to be a phony assignment of mortgage in order to foreclose.
Okay.
They would have no interest of any kind. And I really believe that the case is that simple. We submitted interrogatories to the bank, and the bank gave sworn answers to interrogatories 3, 4, and 8. In each one of those answers, the bank said that they had the right to foreclose because of the assignment of mortgage. And we have shown without any doubt that the assignment of mortgage is defective.
Who held the note?
Who held the note?
Yeah. Deutsche Bank held the note?
I can't recall who originally, Argents.
I guess it was a summary judgment, right? Did
yes.
Deutsche Bank?
Yeah, sure.
The trial.
I'm sorry, I'm looking. Final judgment. Did the bank establish that they held the note?
Did Deutsche Bank establish that they held the note? Yeah. They held the note only after this fraudulent assignment. Yes. In other words, they had possession. I think, if I understand your question,
The mortgage follows the note. If they established that they had the original note, does it make a difference as to what was notarized on the mortgage?
Sure, because even as if in this case it's a blank endorsed note, if a thief holds the note, that doesn't give the thief the right to enforce the note simply and the mortgage simply because he holds the note. And our position is that the bank really has no better position than the thief does, because the bank got it through this fraudulent assignment.
Okay.
Apparently, the lower court, and I think this goes to the question that Your Honor was addressing a moment ago, apparently the lower court based its decision on the bank's possession of the note without even considering how they got that possession. And what we are saying is that there's no question that basic law is that if you possess a note endorsed in blank, it's certainly the most negotiable thing, and it's as negotiable as a dollar bill. Unless, of course, you stole it, or unless, of course, you got it in some way that is tainted. And our whole argument is that that's what happened here, that this assignment, when you look at the signatures, it's brazen. Quite frankly, I've never seen anything like it in more than 40 years that I have practiced. These signatures are so drastically different that it would be impossible for anybody to say that this assignment is legitimate. And that's the only way in which the bank claims a right to this note. And therefore, it's our position that they certainly would not have the right to foreclose, should be reversed, and the court should consider, at least consider, the discrepancy in these signatures. In our exhibits, we showed the official signature. I ordered it from the Secretary of State of California. We showed the official signature of the notary, and also the signature on the assignment. And those two signatures, if you look at them, it takes 5 seconds for any individual to say there's something very wrong here. There's something very wrong with this assignment. That being the case, the bank certainly does not have the right to foreclose based on that assignment.
All right, thank you very much.
Thank you.
You still have 5 minutes for rebuttal.
3 minutes, if I could.
Yeah, you'll have 5 minutes.
Thank you.
May it please the court. David Ehrlich for the appellant, Deutsche Bank National Trust Company. Your Honor, Deutsche Bank respectfully requests that this court affirm the final judgment entered in its favor at the trial court level for 2 primary reasons. First, the appellee proved its case with competent and substantial evidence, and conversely, the appellant did not introduce any competent and substantial evidence.
You're not cross-appealing. The judge denied a bunch of money for back interest and so forth because there was a lack of proof, correct?
That's correct, Your Honor.
That judgment, I don't see too many that are crossed out like that.
Well, Your Honor,
forgot to put on evidence or something like that?
No, that's essentially, Your Honor, the payment history that was submitted in support of the damages claim, the court found that it added up to a different amount that was submitted
but I mean,
in the final judgment. Excuse me?
There's no cross.
That's correct, Your Honor.
The proof you're referring to is the proof of everything but what the judge crossed out.
As the appellant indicated, Your Honor, their quote-unquote whole case is the assignment of mortgage issue. And I'd like to address some salient facts and some points that were omitted from the presentation and from the initial brief itself. In the record, page 158 is the appellant's answer in affirmative defenses, and notably absent is standing as an affirmative defense. And the Supreme Court of Florida has routinely held that standing is an affirmative defense that is waived unless pled. And in this case, Your Honor, there is no standing as an affirmative defense. When that occurs, the only issue is whether the plaintiff owns and holds the note at the time of trial. And that is clearly what the trial court found. This is a case about sufficiency of evidence and not about assignments or standing. This is not a de novo review. And as Your Honors recently held in the Stone versus Bank United case in 2013, a trial court's factual findings are presumed correct when entered by after a non-jury trial.
Tell me if the note and mortgage were signed simultaneously. Or is this one of these deals where the note comes first and later on there's an assignment of a mortgage?
No, Your Honor. The note and mortgage were signed contemporaneously in 2005.
Okay.
This entire case hinges upon a assignment of mortgage that was recorded in 2008 prior to the lawsuit being filed. Or at least it has an effective date of a date prior to the lawsuit. But the issue is, Your Honor, is that an assignment of mortgage is not required to transfer a promissory note. In WM Specialty and in this court's case of Taylor versus Bayview, this court held that the mere transfer of possession of a note endorsed in blank is sufficient to confer standing to enforce the note. And in the present case, at trial, a representative for the plaintiff testified that the plaintiff owned and held the note prior to the lawsuit being filed endorsed in blank. And it's on page 126. And that in and of itself defeats all claims about the assignment of mortgage, because the assignment of mortgage is essentially superfluous. I represent to Your Honor that the appellee still wins, even if everything that appellant argued about the assignment of mortgage was true. That if it was defective or if it was held out of evidence, that the plaintiff still demonstrated a prima facie case for mortgage foreclosure. And that's to the point, Your Honor. This is not an appeal about the admission of evidence. All of the evidence that was submitted to the court is in the court record. This is not an appeal of a court's admission of evidence. There is a note endorsed in blank with testimony confirming that the appellee held the note prior to the mortgage, prior to the lawsuit being filed. The mortgage is on record.
Well, the mortgage passes in equity with the note. That's what you're saying.
That's exactly right, Your Honor. And in the WM Specialty case in Taylor versus Bayview, an assignment of mortgage is totally...
Is this case about a BFP?
Well, Your Honor, that was the second point that I intended to get to. In terms of the BFP argument, this court addressed a case with virtually identical facts in 2009, and I cited to it in the brief, Your Honor, and that is the New Millennial, JP Morgan Chase versus New Millennial. It's 6 Southern 3rd 681. In 2009, this court heard a case with virtually identical facts, and it held that a person that succeeds the mortgagor does not get to rely on a bona fide purchaser argument when they're claiming that an assignment of mortgage was recorded subsequent to them taking title. That is exactly what happened in the present case. And on cross-examination of the appellant at trial, we confirmed that, and it's admitted, that the appellant took title to the property subsequent to the mortgage itself.
Well,
and that's all that matters.
There may have been a defective title search, hypothetically.
Sure.
Maybe they relied on a defective title search, and maybe there might be some other recourse with the title company, but you're saying it doesn't affect your case.
That's exactly right, Your Honor, and that you took the words out of my mouth. I was going to say that if there is any issue, it's with the title company and not with the mortgagee or any subsequent holders of the note and mortgage. And this case, in JP Morgan Chase versus New Millennial, this court heard the identical argument. There's no reason and nothing raised in the appellant's brief that would call into question the New Millennial case. But essentially, Your Honor, this all still comes back to the sufficiency of evidence. There's a note, a mortgage, the payment history, and a breach letter that are all on file. This is not an appeal of the admission of evidence. It's only the sufficiency of the evidence. And under any review of the law of standing in Florida, be it McLean or Riggs, the appellee has demonstrated its standing through the possession and the ownership of the promissory note endorsed in blank on the date of trial. And the appellant has admitted that his quote-unquote whole case is the purportedly defective assignment of mortgage. But again, under the WM specialty case in Taylor versus Bayview, an assignment of mortgage is not required. There's nothing in the law of Florida to say that an assignment of mortgage must be recorded in order to bind to the property. It's simply a memorialization of a transfer. And in the present case, the appellant has harped on the purported lack of congruity between the signatures of the notary. And, Your Honor, in Huff versus State, it was held that a fact finder is not able to, is not competent to make a handwriting comparison without expert testimony. And under oath, the appellant admitted that he himself has no handwriting analysis experience. He did not offer his own testimony as an expert witness. And in In-Ray MEG 353 Southern 2nd 594, it was held that a trial judge sits in the same capacity as a jury. So a trial judge sits in the same capacity as a jury does for the purposes of weighing testimony, assessing credibility, and resolving conflicts. The next point I wanted to address, Your Honor, is the interrogatories issue. The appellant seems to conjure the word solely, not in the record. That word does not appear in any of the interrogatories, and it does not appear in the record. His argument is that the appellee is solely capable of relying on the assignment of mortgage to demonstrate its standing. That's simply not the case. If you read the interrogatories, which I believe are Exhibit 1 to the initial brief, the questions go to how does at the time the plaintiff confer standing, and it is true that the assignment of mortgage is referenced as responsive to that interrogatory, but interrogatories are not ironclad. They don't box the plaintiff in for trial testimony. Any incongruity is simply an inconsistent statement, and certainly subject to cross-examination, which the appellant clearly had the opportunity to do, which he did, which the trial judge dutifully weighed and made a conclusion of fact as to the validity and the effectiveness of the assignment of mortgage. And again, under Stone versus Bank United, this court held that the factual findings of the trial court judge are presumed correct. There's nothing in the record to rebut that very strong presumption. And like I said, the interrogatory responses are not definitive in any way. They reference the assignment of mortgage, but the questions did not say, please list any and all documents to the exclusion of any opportunity to rely on the promissory note. It just they simply request, please reference documents that can demonstrate your standing. And again, this all comes to the threshold issue that the appellant waived standing as an affirmative defense. The appellee simply had the responsibility to prove a prima facie case of standing on the day of trial. And I point your honor to Booker versus Sarasota, which is 707 Southern 2nd 886, in which in the scenario where standing is not raised as an affirmative defense, but it's simply denied in the answer itself, in terms of the paragraph 5 of the complaint referenced that the plaintiff held the note, and appellant denied that paragraph in the answer, the court evaluates standing on the day of trial. And they simply held that the plaintiff simply had the duty to demonstrate it could enforce the note, and be it through the endorsement in blank, be it through the assignment of mortgage, either way, the appellee demonstrated on the day of trial that it held the note and it was capable of enforcement. So under any test, the appellee proved its standing under even the most rigorous standard, which would be a de novo review, but more specifically, because the appellant waived standing as an affirmative defense, this court need only weigh it on the day of trial. And I point your honor to that point. There's two other cases to that point, which is Beaumont versus Bank of New York Mellon, 81 Southern 3rd 553, which is a 2012 case from the 5th District, and Venture Holdings versus AIG Group, which is a 2011 case. from the first DCA. And the dicta in those cases are that in a scenario similar to the present case, where a borrower in a mortgage foreclosure action does not raise standing as an affirmative defense but denies it, that the appellee need only prove it on the day of trial, which under any evaluation did. And further, finally, it should be noted that the appellant stipulated to the entry of evidence of the note, the mortgage, and the assignment of mortgage. And this is, again, only a sufficiency of that evidence case. This is not a scenario where they're appealing the introduction of it. So once that's on record, we simply jump to the presumption that the trial court correctly weighed its facts. To quote In re MEG, that the trial court weighed the testimony, assessed the credibility of the witnesses, and resolved any conflict, any purported conflicts in any of the documents. So again, this all comes down to the non-jury trial's factual findings, which should be undisturbed, and the final judgment should be affirmed. And finally, the appellant's initial brief cites the limited case law. There's only about 5 cases, and 3 of them are a string cite about unclean hands, which is inapplicable. And the others are not illustrative of the present case. This comes, as the appellant freely admitted, this whole case comes down to the assignment of mortgage. Under the WM specialty case, the assignment of mortgage is totally irrelevant. Even if they were correct in precluding it from the evidence, the appellee would still have prevailed. But they didn't. They even stipulated into the evidence. And so it's surprising that they would now argue that it's defective or should not have been considered by the trial court. Ultimately, the appellee respectfully requests that this court affirm the final judgment in its favor and deny this appeal.
All right, thank you. Mr. Fisher, you've got 5 minutes for rebuttal if you'd like to use it.
Thank you. Yes, I will. Your Honor, what the bank is saying here is, you got me. The assignment's defective. These signatures are very different. So just forget the assignment. We hold the note. And they're also saying, don't ask us how we got the note. But the fact is, in their sworn answers to interrogatories, they say that they got the note through the bad assignment. You can't just chuck the assignment. You can't just say, well, okay, forget the assignment. We know the assignment's defective. We'll go on the fact that we hold the note. No question that if you hold a blank endorsement, basically you have a right to enforce that, but not when you got. They're asking this court to simply overlook and ignore the way in which they got the way in which they got the holding of the note. Yes, they held it, but they held it again through this defective assignment. And throughout his whole argument, 4 times he admits that the bank admits that the whole case turns on whether on the assignment. If the bank had said, Deutsche Bank didn't come into this case until 2012. The original mortgage from Argent's is 2005. If the bank had said, we had this assignment and it was a legitimate assignment back in 2005, 6, 7, 8, something like that, we'd have a totally different case. What the bank did simply here is fabricate an assignment in order to facilitate a foreclosure when they had no right to foreclose. This assignment is very clearly a fraudulent, or at the very least defective assignment, and that is the only right that this bank has. The fact that they hold it, they can't jump to the fact that they hold the note without considering how they got it. As I said before, that would be, a thief could do that. A thief could say, well, I hold the note, so that's the end of the story. It's not the end of the story. The way you got the note is very important. And the way you got the note is certainly very, very tainted in terms of this assignment. Thank you very much.
All right, thank you, gentlemen.